I'm Attorney Phillip Jusino, and this is WLINY's Finding Common Ground here on Altice. You can see this show on Saturday mornings at 10 a.m., channel 115, and for your insomniacs, Thursday mornings, 1 a.m. on channel 20. You can also see a live version of Finding Common Ground on Facebook Live at 8 p.m. every Friday. I'm sitting in this chair. You can join the chat room, and then we usually have a watch party afterwards. So if you missed the show, you can catch it later. Got two great topics tonight. These topics came from a program that I came up with called Future Lawyers Institute. It's to give an overview to young people about the legal system. It covers contracts, criminal law, torts, constitutional law, divorce and family law. Tonight, the two topics are contracts, which everyone on this planet at some time in their life, some every day, enter into a contract. It might not be the contract that you think of traditionally, where you, like a real estate contract. It could be you buying a candy bar. That's a contract. We also are going to cover divorce and family law in the second segment of the show. One quote I wanted to read to you because I think it ties into what I'm trying to do. It says, "Educate and inform the whole mass of the people. They are the only sure alliance for the preservation of our liberty." Thomas Jefferson said that. So let's get to it. First topic I want to touch on may not seem as interesting or sexy as some of the other areas of the law, like criminal law, where you can really sink your teeth into it. And you watch TV shows, movies, and you can really understand what's going on, because we all understand what a crime is, a show about murder or something along those lines, or robbery or burglary. We all understand what that is. Contracts is a little more abstract. But it's still a very interesting topic, and the way I'm going to describe it to you, I think you'll be interested and entertained. What is a contract? A contract is an agreement between two or more people, and we contract every day whether we realize it or not. And a contract creates an obligation between those two people or more. It could be a contract between 1 million people. It could be a contract between 2 people, but 2 or more people. And when I say it creates an obligation, it means that they make promises. There's a covenant between the two of them, or more, that they have to carry out certain functions. Whether it be something that takes 2 seconds, like I'm going to hand you an item and you pay me. Or it could be a contract that takes more than a year, or that goes on for many, many years, like an employment contract. And there is a remedy for a breach of that contract. Just like if you commit a crime, you can be arrested. If you breach a contract, you can be sued. And we're going to get to all of that. The first topic, or the first part of a contract, is what they call competent parties. What does that mean? Competent parties are 2 people or more that have the capacity to enter into a contract. Can you enter into a contract with a minor? The answer is yes, you can. But it's also considered a voidable contract, and there are exceptions. So let's say I have a store, and I sell pool tables. And a 17-year-old comes in and says, I want to buy that pool table. And he writes me a check, or however he pays it, and we write a contract. I'm going to deliver the pool table to you on such and such a date. And I do that. That contract is potentially voidable, not void. Void would mean no contract. Voidable means he can call me up and say, you know what, I really couldn't afford that. It was a dumb thing to do. I want my money back. And I would have to give him, that 17-year-old or 16 or 15, their money back. Because they're not an adult in the eyes of the law that can contract the same way that an adult can contract. The exception is for necessaries. But let me go back 1 second. That's why I might say, I'll sell you that, but have your parents sign the contract. So this way I have somebody to go after, and the contract would not be considered voidable. So when you have a voidable contract, the exception to that would be for necessaries. So if a minor contracted with an adult over something that's a necessary, it could even be housing or food or something like that. If the person who made the contract with the minor can show that it was for a necessary, a pool table is not a necessary. A lot of things are not a necessary. So that would be a voidable contract. If it's a necessary, the contract would be upheld. The next one is a legal subject matter. You can't enter into a contract dealing with illegal subject matter. So in other words, I couldn't contract with somebody to say, I'm going to sell you an ounce of cocaine. It's against the law. The law would not uphold that contract for obvious reasons. It's illegal. The same with prostitution. The same with a lot of things that are considered illegal. If, let's say, two people want to sell a gun that's not allowed to be sold, that would be an unenforceable, void contract. So the subject matter has to be legal. The next part of a contract is legal consideration. So if I said to you, I'm going to give you my car, and you said, thank you, drop it off, and I don't do that, could you sue me for not dropping my car off to your driveway? No, you couldn't. Well, you could sue, you wouldn't win. Why? Because there was no consideration. Now, if I said, I will sell you my car, it could even be for $10 or $100, $1,000, whatever, that's consideration. In other words, I'm giving up something, and so are you. I'm giving up my car, you're giving up an amount of money, that's consideration. You need consideration in a contract. There are exceptions, but we'll get to that. Mutuality of agreement, that we're on the same page. So if I say, I'm going to sell you my car for $1,000, and then I drop off an old Gremlin vehicle instead of the Mercedes that you thought you were getting, we're not on the same page. That contract can be set aside. That's why you want to be specific as best you can in a contract. I'm selling you my 2015 Mercedes. It's black, it has this, whatever. Or VIN number, it's even better, because then you know exactly what vehicle you're talking about. So we said mutuality of agreement. The next one is mutuality of obligation. Again, that there's consideration, we're all on the same page, and we each have an obligation, as opposed to a gift. In other words, this for that, or a quid pro quo. You heard the Latin phrase, this for that. Mutuality of obligation. So the things I just went through, competent parties, legal subject matter, legal consideration, mutuality of agreement, and mutuality of obligation. You need all of those things. If one of those things is missing, you don't have a contract. Now, I'll give you some examples of contracts to really drive the point home. An obvious one would be a real estate contract. You want to buy a house, an attorney drafts the contract up, you sign it, it's a binding contract. If you don't go ahead with it, you can be sued, or you can sue the other side if they don't go forth with that contract. Now, a real estate contract must be in writing. There's a thing called the statute of frauds. Certain contracts have to be in writing. You cannot do a handshake and say, okay, I'm going to buy your house, I'm going to pay you $300,000. Handshake. That would not be enforceable. It would have to be in writing. Another thing that contract that can't be done or must be in writing is a contract that cannot be done or completed within a year. So if I contract with someone, I say, all right, I'm going to hire you for 18 months. That has to be in writing, as opposed to, I'm going to hire you for 6 months. That can be done. Or if it can be done within a year, you don't have to have it in writing. Another example of a contract, very simple, every day. You go to buy a candy bar at a deli, or you go to buy a candy bar in a machine. You either put money down on the counter, or you pop some coins in or a bill into a machine. It spits out a candy bar. You just entered into a contract with the owner of that candy bar and yourself. That's a contract. If it says put $1 in and you put 75 cents in, you don't have a contract. Another one would be you find a lost dog, and there's a sign that says, if you return my Rottweiler, I'll give you $100. You find the dog, can't steal it. You find the dog legitimately. You knock on the guy's door, you say, here's your dog. Does he have to pay you $100? Yes. You completed the contract. That's a condition precedent. You have to find the dog. You can't knock on his door and say, look, I'm going to look for your dog, and if I find it, you could have an agreement, but that wouldn't be a contract. The contract is completing the task by bringing that dog to the owner that lost the dog. Then they have to pay you. Another example of a contract where you see all the time, maybe less nowadays because you have landscapers. But when I was a kid, I mowed lawns. I shoveled driveways. That was a contract. And I talked about voidable and void, but for the most part, or a kid with with a lemonade stand. That's a contract. You walk up to that kid and you pay him $1, he gives you a glass of lemonade. That's a contract. If you hire somebody to do your lawn and they complete the task, you have to pay him. That's a contract. There are exceptions. Let's say he's doing the lawn and he's not even half done and he gets tired. He says, you know what, I don't like this anymore. Just give me the money, I'll go home. You don't have to pay that guy. He didn't complete the task. Now, flip it around, and let's say he's mowing the lawn and he's 95% done and it starts to rain. Unless you make other arrangements, he could say, look, I've specifically performed and substantially completed the contract, I want my money. Or if you say, look, I got to run to the store, I got to leave, I'm sorry, you have to go home. If he mowed most of that lawn, he can claim substantial performance of the contract, so he can get paid. Now, what is a breach of contract? A breach of contract is when you don't live up to the terms and conditions of the contract. Very simple. So if I contract with you, you're going to buy my house. You put in there, you're going to spend $500,000. We're going to have a closing down the road, and you're going to buy my house. You put money down on the contract. If you, let's say, find a better house or a better deal, and you come to me and say, you know what, I can get a better house than yours for $400,000 down the block. I want my money back. He's in breach of that contract. Now, depending on the wording of the contract, I can keep his down payment, or I can sue for specific performance and say, I want you to pay me. You have to go ahead with that deal. Now, sometimes in there it just says you keep the down payment, so you keep the 20 grand, and that guy's out 20 grand. You got 20 grand, you still have your house to sell, and you can go forward and do that. But a breach is defined as a failure without legal excuse to perform any promise which forms the whole or part of a contract. Now, without legal excuse, I'll give you an example. Let's say, as an attorney, someone signs a retainer. That's what we call, that's the contract between attorneys, a retainer agreement. So you give me a retainer of $5,000 to handle a legal matter for you. And let's say something happens to me, I become ill, and I can't complete that contract. I would have to give you your money back. Could you sue me? No, because the legal excuse is I'm ill, let's say. So you would be able to get your money back, and I would be able to get out of the contract. Because there it's more of a special type of relationship between an attorney and his client or a doctor. It'd be different if you went to the deli and you said, I got a catered affair, I want to pay you a certain amount of money, and you're going to make 50 sandwiches, a potato salad and all that, and you're going to come to my house and drop it off on the weekend for my party. And let's say that one of the guys in the deli who usually makes the sandwiches gets sick. Well, someone else can do it. It's not a big deal, unless there's only one person at the deli. But with an attorney, if I say, I'll get you another attorney, you might not be satisfied. You might want me, Phil Jusino, because someone referred you to me. Well, you know I'm very good at what I do. Well, you know that's the kind of case I really handle well. You might say, I don't want another attorney. And if the retainer specifically stated, you're hiring Phil Jusino and only Phil Jusino, as opposed to, I have people that work for me, I might send somebody out on a case that I feel is appropriate, where my expertise might not be needed, or I already worked out the deal like in a criminal case. I might have already worked out the deal, and an attorney, an associate, or someone who's on counsel can go down and complete the deal, so to speak, and take the plea. Now, what types of damages are there? I told you in general, it's when you breach a contract, you don't live up to the contract. There are damages. Just like in a criminal case, if you hurt somebody, they are injured, or in a tort action where you hit, let's say you run somebody over with your car, they can sue you for damages. Well, contracts has the same principle. You sue for damages. There are actual damages. Actual or obvious. What the person is out. If I'm going to sell my house to you for $500,000 Those are actual damages. I'm out $500,000 because you didn't buy my house. Punitive damages for outrageous conduct. You don't see that too often, but it would have to be something very, very outrageous. Like in tort law, remember last show I gave an example. You're in your backyard and you take your bow and arrow and you shoot it. And the arrow goes up in the air, comes down and hurts somebody. You could be arrested, but you could also be charged, or you could be sued, I should say, for gross negligence, where it's not like you're just driving your car and you don't pay attention, you hit somebody. That wouldn't be gross negligence under most circumstances. You're going 90 on a curb, that's gross negligence. Punitive damages are rare with contracts, but if the damage is so severe or the conduct is so egregious, there could be punitive damages. Nominal damages could be just a matter of principle or for vindication. So some years ago, Donald Trump had a team in the XFL. He might have even been running it at the time. And they were competing with the NFL. There may have been some contracts. And they sued for some kind of breach. I don't know, have all the details, but there was a lawsuit. And the court said Donald Trump won. But I think they gave him $1, something nominal, to say, you really didn't sustain a damage. I'll give you an example. Let's say you're going to buy my house at $500,000. And you say, forget it, I don't want to buy it. And then the next day, somebody comes, knocks on my door and says, I want to buy your house for $500,000, or more than that. In other words, I'm not suffering any loss, as opposed to somebody saying, I'll pay $450. Then my damages would be $50,000, because I thought I contracted for $500. Somebody paid me $450. I mitigated my damages. I just didn't throw my hands up and say, I'll never sell it. I sold it for $450. I could sue for $50. But in the case where someone says, I'll pay you $500,000, could I sue that person for breach? But what are my damages? The court could say, all right, you're right, we'll give you $1. You didn't suffer any damage. You sold the house right away for the same amount of money. No damages, maybe a moral victory, you get $1. Let's talk about gifts. Gifts are given without consideration. So if it's your birthday and I give you a gift, we didn't contract. I didn't say, I'll give you a gift if you give me $10. That wouldn't be a gift. That would be a contract. So let's say, I gave the example a little bit earlier. Let's say I say to you, I'm going to give you this watch as a gift. And I never get around to it. And you knock on my door one day and you say, hey, Phil, what about my gift? You never gave it to me. I could say, you know what? That was ridiculous. I shouldn't have promised you the watch. Can you sue me? No. Because there was no consideration. It was a gift. Let's change the facts a little bit. Let's say I say to you, here's my watch, and I give it to you. And the next day, I say, you know what, that was stupid of me. I bought this watch in Beverly Hills on Rodeo Drive, and that really meant something to me, or it was given to me by my parents. I would never give that watch away. But let's say I did, and I said, you know what, I made a big mistake. I want that watch back. Can I get that watch back? Let's go through the analysis. Is it a contract? No. Is there consideration? Is there legal subject matter? Yes. Was there legal consideration? We just said no. Mutuality of agreement? Well, sure. Here's the watch. You took it. And mutuality of obligation. Could be argued. Sure. I took the watch. You gave it to me. It was a gift. The difference is because it's a gift, we have a situation where once the gift is completed, right? Once the gift is completed, I gave you the watch, as opposed to promising you the watch. The gift was completed, or the act was completed. That watch is yours. I could say give it back. You could say, no, I'm not going to give it back. Right. What about a donation? Like let's say we heard in the news about some parents giving a lot of money to colleges or people to help their kid get into college. Let's use an example. I went to Fordham Law School, and they get a lot of money from donations. Let's say I called Fordham University, and I'm a millionaire, and I say, I'm going to give you $1 million because I really loved Fordham University. I did well. It started me off on my career. I was very successful. I want to give back, and I want to set up a scholarship fund, let's say. So I'm going to give you $1 million. And the school says, thank you. And because we're going to get $1 million, we're going to break ground, and we're going to put a new building in. And that $1 million you give us is going to fund that building. And I say, wonderful, do it. And they can prove that I made the promise. right? I don't deny it. And months go by, and I say, you know what? I really got hit by a couple of my stocks didn't do too well, so I really don't have $1 million anymore. And that was a gift. It wasn't completed. Can Fordham University sue me? I would hope they wouldn't, but they could, right? Under an estoppel theory, I made a promise, and this was not like, I'm going to give you my watch. This was such that they changed their position. They spent money. They went out and did something affirmatively, and I was aware of it because they said to me, we're going to name that building the Phil Jusino wing, or Phil Jusino building. And I didn't say, forget it, I'm not going to do it. I went along with it. And at the last minute, I pulled out. They could sue me and force me to give them that money, even though it was under the theory of a gift, but it was an estoppel. They changed their position, or they did something, because they would have suffered a damage. If I didn't give them the $1 million and they didn't have the money from another source, what do? They don't build the building, they leave it the way it is. So that's it with contracts. Very, very important topic, because even if, like, let's say you never get arrested, or you never get a divorce, or you never go to family court, we enter into contracts every single day of our lives. You go to Taco Bell, you're entering into a contract. So it doesn't only have to be for a large, expensive purchase. We all go to delis and restaurants. That's a contract. So very, very important topic. The next topic I want to get to is matrimonial and family law. Very important topic. A lot of people find themselves in a situation, if not themselves, maybe a child of theirs or a relative or a parent that's going through a divorce or finds themselves in need of an attorney for a family law matter. So let's say the parties are not married, but they have a child in common. Or they get into an argument and an order of protection results. Or they have a child and someone calls CPS on them. There could be a neglect petition filed. Or there could be an adoption, a happy day. In family court, the happy day in Suffolk County is a Friday when they do the adoptions. So there people aren't fighting, the family is growing, a child is being adopted. So let's start off with divorce. Divorce is defined as the legal separation of married individuals. With a divorce, it ends with an order. It's called the judgment of divorce, which says you two are divorced. So prior to that, if a case is settled, you sign an agreement or a stipulation of settlement, settling all the terms, custody, child support, what happens with the house, credit card debt. Think about everything in your life with regard to your relationship with your spouse gets set forth in that agreement. But that doesn't officially give you the divorce. That document is submitted after it's signed by the parties and duly notarized. It becomes the basis upon which the judge grants the divorce. And once you're divorced and that judgment takes effect, anything after that would be called post-judgment. So if someone doesn't meet their child support obligation, there would be a family court proceeding. Or if someone doesn't sell the house they're supposed to sell, that would be a post-judgment in Supreme Court. So let's go through the categories in the realm of divorce law. You have, we just said, a divorce, where the parties want to be divorced. They go through the process, they sign the agreement, a judgment of divorce is signed, they are divorced, then they can remarry. There's also a legal separation. Now, if I showed you a legal separation document and a divorce agreement, you'd look at it, and with the exception of a little language in the beginning of the document, you could not tell the difference. It's identical because think about it. That separation agreement is a contract. At that moment, it doesn't go to court. The parties don't get divorced. They stay separated so they can stay on each other's insurance. That's one of the reasons why people get a legal separation. They're still legally married. Usually they'll live separate and apart. They don't have to, but generally that's what they do. But the difference is with the separation, they're still married, it doesn't become a divorce. A year or more later, so the definition of legal separation, the parties are going to live separate and apart, and a year or more down the road, either party can convert that separation agreement to a divorce. And then the parties will become divorced. That's why that agreement has to be airtight and cover all of the terms and conditions that the parties need to address. Because if you had a separation agreement, let's say you said, you know what, let's do a separation, but let's not address the house issue. Or let's not talk about maintenance. What are you really getting? Nothing. Because in a year or so, someone says, you know what, I met somebody, I want to get divorced. I don't want to stay separated anymore. You submit that to the court, but what happens now with maintenance? You'd have to litigate it. What happens with the house? You'd have to litigate it if you couldn't agree. So that separation becomes the basis for the divorce a year or more down the road. People can stay legally separated until one of them dies. They don't have to convert it to a divorce. Now, when I mentioned a little while ago about medical insurance, sometimes, let's say the husband is ill and he has cancer and the wife has the insurance. Once the judgment of divorce is signed, that husband no longer has insurance. And if he has good insurance with the wife, they can do a legal separation. So he can stay on her insurance while they're legally separated. And usually I put language in there that would say if the wife converts it within a year or within a certain period of time, she would have to pick up a policy for the husband. I might do it 5 years, 3 years, or whatever. So this way, because think about it, if you, as an attorney, I work out a great deal for my clients. So you're going to stay legally separated so you know you have insurance. But at the end of the year, the wife can convert it to a divorce. If I don't put that language in there to protect my client, we're saying if she converts the divorce, not him, because he wouldn't do it unless he had a backup, but she converts the divorce within 5 years, let's say, she would have to agree, then she would have to pick up a policy, an equal policy, a comparable policy, not a bad policy, for the remaining period of time. So at the end of 3 years, let's say she meets Mr. Right, says, I want to get a divorce. She can do that. But let's say it's year 3 and we contracted for 5 years, she would have to go out, find a policy that's equal to what he has, pay for it on her dime, and then at the end of the 5 years, 2 more years, then he's on his own. But at least he knows, okay, I got 5 years of coverage. Another category in a divorce that has to be discussed is what they call equitable distribution. Equitable distribution is a situation where the parties have assets and the court has to, if the parties can't do it themselves, have to decide how assets are going to be divvied up. And if they can't agree, then the judge will decide it based on the laws of equitable distribution. Right? And that's in the domestic relations law. And it gives the judge guidance as to how to divvy up property. But if you're going to divvy up property, there's 3 things you have to do first. So it could be a car, it could be a house, it could be a pension, it could be a vacation home, anything that has value. First, you have to classify it. Is it a marital asset? If it's not a marital asset, it doesn't get divvied up. So if I own a house and I go into a marriage, and assuming I don't put my new wife's name on it, and no marital funds are used to keep the house going or to pay for the mortgage, that house does not get divvied up in a divorce. That's my separate property. And I'm doing an overview. There's a lot of nuances that would have to be addressed. You know, was it commingled an asset? Was it transmuted? Those are a little bit more heavier topics. And in a prior show, if you go to one of my prior shows here on Altice, I talked about that, where I get into the nitty-gritty. So first, is it a marital property or is it separate? Sometimes it's a hybrid. And then the person gets a separate property claim, but classification is the first step. Valuation is the next step. If it is marital or partly marital, what is it worth? Because you can't divvy it up until you know what it's worth. Now, if the parties are going to sell the house, then you don't necessarily have to value it. Just put it on the market, it sells, you split it. But if there's going to be, as I call, horse trading, where someone might get the house or a portion of the house, you need to know its value. The same as a car. If the parties are getting divorced and one party has a 2018 Mercedes and the other one has a 2010 Nova, that's not of equal value. How do you determine the value? With a car, it's easier, let's say, than some other assets. You go to Kelley Blue Book and you look it up and you say, this car is in excellent condition. It's a 2017 Mercedes, SL, whatever it is. You compare apples to apples and you come up with a value. You do the same thing with the other car. So if the Mercedes is worth 100 and the Nova is worth 90, that's to combine, I said 90 and 10, $100,000, each one would get 50. So if she has a $10,000 vehicle, let's say the wife, he would have to give her $40,000 to make her whole, even. Another way to value it is to hire an expert. Like if you want to find out what a house is worth, you can get a market analysis, you can pay somebody to value the house. And they'll say the house is worth $500, you owe $300, so there's $200,000 of equity. That's a way to do that. Sometimes with cars, you still need an expert. I had a case one time where there was antique cars or cars that were hard to determine its value, like muscle cars that were souped up, not just where you go to Kelley Blue Book and say, okay, I need a 2010 Honda. No. We got an expert who came to my parking lot, looked at the car, and gave us a value. And you have to pay the expert. Sometimes it's $500 to determine the value of a house. Sometimes it's more. Like an antique dresser. What is it worth? I don't know. Let's get an expert. They come in, they say what it's worth. So if the wife is going to keep it, but it's a marital asset, it's worth $1,000, she'd have to give the husband $500 or $500 credit somewhere along the line. Another topic that's discussed in divorces, which is also in family court, there's a lot of overlap. Equitable distribution would not be addressed in a family court proceeding. That would have to be a divorce. Child custody, visitation, and parenting time would. My producer is reminding me to like, share, subscribe. When you watch these shows, like if you watch it on Facebook or if you watch it on YouTube, you can subscribe to get the word out. So with child custody and visitation, it means just what it says, custody of a child. So you can do that in family court, you can do that in a divorce action. If the parties can't agree, and it's always best if the parties can agree rather than have to have a judge decide. Like most judges will say, do you want someone like me who knows nothing about your life to make a decision on who gets the child or children when dad or when mom sees them? Or do it yourselves. And it's a lot cheaper because if you have to have me do it, it's going to get more expensive. The same as the other attorney is billing, I'm billing. There might be attorney for the child that's billing. So somebody's paying for either one or two attorneys or maybe three. Let's say the husband makes $200,000 and the wife is a stay-at-home mom with triplets that are 1 year old. Dad's paying for all attorneys in all likelihood. Right? There are exceptions, but in a case like that, he's paying. So in a custody case, if the parties can't agree, you may have to get an attorney for the child, which is called an attorney for the child. It used to be called a law guardian. I was one for 5 years, many years ago. The attorney for the child or children would speak to the kids if they're old enough to be spoken to. Obviously, you got a 1 year old, you do the best you can. You can't speak to them, but you could talk to mom, you could talk to dad, maybe you talk to the grandparents. You look at the house or you send somebody down to see what the environment is for each household if there's a custody battle. And that attorney would make a recommendation at some time where the children should go. It's not controlling, but it's a recommendation. And what the attorney for the child says has more weight than what I say as an attorney for one of the litigants or another attorney for one of the litigants, because I am not looking out for the kids. I know that sounds kind of harsh, but my job is to zealously represent the interest of my client, whether it be the husband or whether it be the wife. Not that I don't care about the kid, but my job is to just they say to me, I want custody. Even if I think, let's say, they're not the better parent. That's what I'm fighting for. Now, I might be honest and say to them, look, I don't know if you can, let's say I have a husband who works 90 hours a week and he's really not a hands-on dad and there are little kids. I might say, look, you're going to spend all kinds of money and you're not going to win. Unless mom is an alcoholic or a drunk, you could be a great dad, but you're not going to win. Or if I have a mother, let's say, has a drug problem, and dad has been a stay-at-home mom or is able to take care, I'm going to be honest with my client and say, yes, you can pay all kinds of money, you're probably not going to prevail. Let me work out the best deal possible. Right? In a custody case, it could eventually go to trial. The evidence is submitted to court, testimony, witnesses. You could have, and they don't usually like to testify, a teacher testify as to, let's say the mother's a hands-on where the father's not. Teachers don't like to testify. I don't blame them. Or a doctor. I have a custody case now where a pediatrician testified. to give testimony for the benefit of my client. The judge hears that and will weigh the testimony and decide whether my client should prevail or the other side. Another part of a divorce case or family court, this is another one that can be overlapping, is child support or maintenance, or indoor maintenance. So child support would be, there are kids involved and the non-custodial parent, the one that doesn't have the kids on a regular basis, has to pay child support. One kid 17% of his gross adjusted, 25, 29, and goes up like that. That would be based on his income, and then they take out FICA, and they calculate the obligation of that parent. That's called child support. Sometimes if the parties make the same amount and they're sharing custody, well, true sharing. I'm not talking about joint custody. People think joint custody means 50-50. It does not. It's just, I always say to my clients, joint custody, sole custody, there's not a big difference. There are subtle differences. But you could call it sole. That doesn't mean that other parent is less of a parent. They still can be advised and consulted with concerning health, education, and welfare. They're still a parent. They have a right to get school records, medical records. So sometimes it sounds warm and fuzzy to say joint, but what really matters is the language that follows the title. It's just a title. I always say to my client, let's say I have a husband, father, and I say, let's say we called it sole custody to mom, but you saw your child every weekend and 3 days during the week. Or we call it joint custody, and you see your kid 1 day a week. Their response is, I don't care what you call it. I'd like joint custody, but if that's it, I'd rather have it, she has sole custody. The point I'm making is it's the terminology that is in the agreement as to what the father's rights or the non-custodial mother's rights. And there's no book that says mom wins. All right, the younger child, I'll be honest with you, mom could have an advantage, especially if she's breastfeeding and the child is 6 months and the father's working, 50, 60 hours a week. But you're not going to look in a book and say mom wins. Every case is different. You have to look at it. Another one would be in a divorce, not in family court, debt. We all, I shouldn't say all, many of us have debt. It could be a credit card debt. It could be a student loan. That has to be divvied up in a divorce. Sometimes one party assumes all the debt. Sometimes it's split up. Every case is different. It's not enough to say whose name is that credit card in. So let's say there's a Visa card and it has $15,000 on it and it's in mom's name. The husband doesn't automatically get the right to say, it's in her name, I'm not paying it. What was it used for? If it was used for household things and the benefit of the children, it's a marital debt. So dad would be either 50% or maybe more than 50%. Give an example. Let's say the party split up and dad is not giving the mom a penny. And before she has a chance to get to court, she's using that credit card repeatedly and it's going up and up and up. Where the husband should have been giving her money all along. The court can say, that's your debt, fella. Because if you were giving her her money, she wouldn't have used that credit card. I have cases like that. She wouldn't have had to use the credit card. Now, let's change the fact pattern a little bit. Let's say it's a credit card in the husband's name. And he says, it's marital. And I represent the wife, let's say. I want it to be 50-50. I ask, where did the debt come from? Did he use it for the benefit of the children? Or did they go on a family vacation? Or did he use it to put a new roof or boiler in the house? Then it would be marital. If the husband used it to take his girlfriend to Vegas or to go on a trip with his buddies fishing, that wife is not paying a penny of that debt. The same as if the wife used it to buy a fancy fur coat and she was going to leave the marriage with that coat. It's her coat, it's her debt. A lot of times student loan can go the same way. Again, there are exceptions. Now that happens with a divorce. So one other topic I want to talk about. Pensions and 401ks. People ask me that all the time. Am I entitled to, let's say the husband's a cop, and wife asks me that question. Yes, you're entitled to half his pension for the time you were married. There's a Majaskis formula. There's a numerator, there's a denominator. It's easy if let's say he became a cop after they married. Then she gets 50% up to the time they file for the, whoever files for the divorce, 50%. If he's a cop prior to that, a company has to factor out his separate property claim. So if he became a cop in 2000 and the parties married in 2010, that period of time from 2000 to 2010 is his separate property. She gets half from 2010 when they married to when the divorce was filed. They can agree otherwise, but that's what the law will allow. I've had cases where the husband might say, I don't think it's fair. I worked for that. They were married. That's why there's a formula. If he was a cop prior, he gets credit for that separate property claim. Family court is a court that has limited jurisdiction. In the Supreme Court, you can sue for just about anything. Family court, you can't sue for a divorce. You cannot get a divorce in family court. You can't divvy up the assets in family court. Even if you want to, that court does not have jurisdiction to do that. But family court can touch on custody, just like Supreme, child support, maintenance, neglect cases, adoption. They can talk about medical insurance. These are the things family court can talk about. So we already went over custody. It's the same. Whether the custody is filed in family court or Supreme, it goes along the same path. Now, sometimes there's an advantage, and you probably won't find this in any book. There's an advantage to seeking custody in family court. Cheaper and quicker, generally. Because if you go to Supreme Court, the case can be drawn out a little bit, and if you get an attorney for the child, usually the parties have to pay for that attorney in some proportions. The court could say, all right, guys, you got to come up with $3,500 for that attorney for the child. Now, if the husband, let's say, makes 100 and the wife makes 50, it's going to be 2/3, 1/3. If they both make 50, they're going to split it. If the wife's not working, the husband may have to pay it subject to reallocation, where later on the court could say, okay, he laid it out, but he's going to get a credit of 50% somewhere along the line. With regard to custody and visitation, that, again, goes the same way. You still have an attorney for the child, but in family court, they generally appoint somebody for the children that the parties don't have to pay for. Panel rates. They're on a panel, and they get appointed. Now, some of the things I'm telling you, again, you're not going to find in a book. It just goes because of my experience that I know what happens. So if you see an attorney and you don't have a lot of money, but you want to address custody, that's the most important thing you can do in your particular case. You don't really care about the divorce. That can come later. Go to family court. You're not going to get a divorce in family court. They're not going to divvy up the house, but maybe you don't need it that quickly. Your concern is, I got to get custody. Go to family court. You file a petition. The attorney can file a petition for you. And you go to court. You appoint an attorney for the child. It's free. You're not paying for it. Sometimes the parties make quite a bit of money, and the court can say, and I've seen this happen, wait a second. Husband's making $200,000, wife's making $100,000. We're not going to pay the attorney for the child panel rates, which is like $70 an hour. We're going to pay him $3.50 an hour because you people have the means to do that. The court can do that. And I've seen them do it. It doesn't happen every day, but it happens. Also, grandparent visitation. I didn't mention that before. You don't go to Supreme Court for that. You go to family court, where grandparents in New York have rights, especially if their child is deceased, to see their grandkid or grandchildren. If this kid is alive and says no, there's certain things they have to show. They made an effort, or they have a relationship and the effort was frustrated. So that can also be handled. So if you're a grandparent, you say, I'm not seeing my grandkid, you can contact me and we can discuss your options, what your rights are. In family court, as I said before, you can also do abuse and neglect. That's where, let's say, a child is being abused and a neighbor or the police or a teacher or a family member calls CPS. CPS does an investigation and finds that a mother or father or both are abusing a child. They're going to be on the radar with CPS. They're going to do an investigation. Within 60 days, that party will be notified if it's indicated, meaning they got a problem, they got to fight it, or if it's unfounded, like being found not guilty. But within that time, if it's serious enough, if it's abuse or something like that, they're going to find themselves in family court. Usually what will happen is the next day, someone will come knock on their door, if they're there, give them a piece of paper, or put it on their door saying, I want to see you in court by 2 o'clock this afternoon, or the next day, to take that child away. Or they can do it immediately. They can send CPS saying, we're taking your kids, right? They have to have due process, and let's say the next day, the people come into court, and they could say, I want my kid back, I didn't do anything. Then the judge will decide. Sometimes they put the kid in foster care. Sometimes they put the child with family members. They always try to put the child in the best situation possible, which would be, let's say, grandma or grandpa that can adequately take care of this child in the area. They don't want grandma from Florida doing it. They prefer the child to stay within the jurisdiction. They can monitor it. They can go to the house and make sure that the child is being taken care of, and making sure that maybe the parent that abused the child doesn't get to sneakily see the child. We talked about support proceedings. What about juvenile delinquency, where JD, a child, commits a crime? Let's say a 14-year-old does something. That wouldn't be in criminal court. That can be handled in family court, right? Still a criminal violation, but it will be handled in family court, which it's not going to follow the child. Family offense proceedings. I could do this for a couple of hours. Family offense proceedings is a situation where, I'll give you an example. Let's say a husband hits his wife. The wife can come into family court and get an order of protection against the husband. She can also call the police. So she can have the husband arrested for either assault or harassment, and also get an order of protection in family court. You used to not be able to do that. You can now. In fact, I had a case recently where we got rid of the family court order because it didn't pay to keep going back to family court when the wife had gotten an order of protection in criminal court. You don't need two. Doesn't give you more protection. So that's an example of family court, family offense proceeding. It could also be anything where there's a relationship. Could be mother, son, brother, uncle, cousin, two people that have a child in common, boyfriend, girlfriend, husband and wife. That could be in family court. If there are two neighbors, let's say I have a neighbor to my left and he's giving me a hard time and I go out there and he says, I'm going to kill you. I can't go to family court to get an order of protection. I could call the police and get an order of protection in criminal court, but in that example, not family court. That's an important distinction. Right? And now, sometimes in family court, I might advise my client, it depends on the situation, but maybe not have the husband arrested, but get an order of protection in family court. You can still kick him out of the house. You can still get the same protection as a criminal court would provide. The difference is he's not arrested. I'll give you an example. Let's say by being arrested, he loses his job. That's a problem because he might not have the money to pay her maintenance and a child support. Now, I'm not saying a guy that beat the heck out of his wife. That's different. I'm talking about maybe he did something stupid. He made a threat that he shouldn't have made. Maybe the best way to handle that is family court. You get the guy arrested, right? Or a woman arrested. It goes both ways. The person may lose their job. They lose their job, they're going to lose their income. They lose their income, they might lose their house, or the kids might not have support. And they might have to go on public assistance. It could spiral things out of control. So it's always best to talk to an attorney like myself to find out what your options are before you do something you might later regret in court. You might file something and say, oh, geez, I shouldn't have filed it. Well, talk to me first before you take that step that you might regret. Now, also important to know, if you get an order of protection against somebody, they're going to have to surrender if they have any weapons, especially guns, things like that. Right? If they're a police officer or a peace officer or a court officer or a corrections officer, it might cost them their job because they're a police officer on patrol. Without a gun, they're not going to be able to do that. They might get desk duty, which means the income might be reduced. So talk to an attorney first. Find out your best course of action. If someone does something really bad, okay, I understand. They may have to be arrested, no matter what they do for a living. But talk to an attorney first before you do something that later on could come back to haunt you. Adoptions. I said earlier, Friday is the one happy day in Suffolk County Family Court because that's when they do adoptions. Different kinds of adoptions in family court. You could do an adoption where a couple adopts some child. I've done this in China. I had a case where they adopted a handicapped child from China. I give them a lot of credit. And that went through family court. Paperwork gets done, or you could have one where they know a parent who's going to have a child, and the parent says, I don't want to, let's say she's pregnant, I don't want to abort the child, I want to give the child up for adoption, and they could work out a deal. The other way is, let's say you have a man marries a woman who has 3 kids. Let's say the father of those kids is deceased or out of the picture. That man can request to adopt those 3 kids. If the father's dead, then it's easy. If the father is alive, you have to get his consent. Right? You can't just do it without his consent. Even if it's ridiculous that let's say he lives in another country and he never sees the kid, but he wants to be spiteful. You still need that. There are some exceptions, but you need that. Again, my producer is always on top of things, and he's saying, if you see this show on Facebook or on YouTube, like, share, subscribe. This show will later on be seen on YouTube, and it can also be later on seen at Facebook at some point. So when you go there, go to WLINY, Internet Radio, and you can see this show later on. So it's like a library. So if you have questions, or you heard that I did a show on equitable distribution or criminal law or tort law, you can go there and see it and get the information from that. Guardianship. Someone gets guardianship. Well, it's like custody, but it's called guardianship. You can do that in family court. Grandparents can also, remember I said grandparent visitation? Grandparents can also fight for custody. Right? There, it's a higher standard. All right? You have to, it's not just best interest of the child. Bennett v. Jeffries case. We have to show extraordinary circumstances, meaning the parent neglected or abused the child, or didn't feed the child, or something along those lines. Then the grandparent can fight for custody. I'll give you a perfect example. Remember years ago, the Elian Gonzalez case. That was a case where a mother and little boy, Elian Gonzalez, came from Cuba. They were on a raft. They made it here. I believe the mother died, and the child made it here and went with the grandparents. The father in Cuba found out about this, and he sued for custody here it was Florida, and the issue was, where should the child go? Stay here in America where he wanted to stay, very happy. The grandparents weren't rich, but they certainly had all the modern conveniences. Or send the kid back to dad in in Cuba, where the child would live under the Castro regime and not have the modern conveniences, not have the same opportunities as somebody born or living in America. The court ruled that the child had to go back to the dad. The dad didn't consent. In fact, I think the mother did it without his permission. Took the child, came here. This is the one, there's a famous, in fact, maybe my producer can get it on the screen. There was a famous photograph of when the judge made the ruling, a guy, I forget what agency, he was like a SWAT team. He went into the house, and I think more than one, and he had a rifle and it almost looked like it was trained on the child or near the child, and the child I think was with a family member, and the child was crying. And they took that child out of that house because a court order said that the child had to go back. Now people looking at this say, wait a minute, that wasn't in the best interest of that child. That's not the law. Best interest would be parent to parent. Mother and father fighting for custody. That would be what's in the best interest of the child. Or, let's say mom and dad were killed in a car accident. you would have a situation where, let's say, grandparents, and I've had cases like this, competing for the custody of the child. That would be the best interest because it's equal. The grandparents are on the same level with each other, as opposed to a grandmother, let's say, fighting for custody, like in the case with Elian Gonzalez, where the father was in Cuba. Dad won, the kid was sent to Cuba. Now, a lot of people could say, wait a minute, that poor kid. That's the law. Right? So a couple of quick quotes. I'm asking my producer how much time we have left. Oh, wow. I'm not going to get to the frequently asked questions. I'll have to do that in another segment. A couple of quick quotes I just wanted to throw out there. The leading role for a lawyer, as for any man of any calling, is diligence. Abraham Lincoln said that. So whatever you do, whether you're a plumber, whether you're a teacher, whatever you do, diligence will raise you to the level you should be at. Right? So, you know, I always tell people, be the best you can be, whatever that happens to be. Another one by Abraham Lincoln. You can tell a theme here. I like Abraham Lincoln. Never stir up litigation. A worse man can scarcely be found than one who does this. Meaning, try to settle. That's what I try to do, if I can. Sometimes I can't. I was on trial this afternoon. The case couldn't be settled. We finally settled it on the second day of trial. One more quote. When you go into court, you are putting your fate into the hands of 12 people, and it's a criminal case, who weren't smart enough to get out of jury duty. I thought that was pretty funny, and that was Norm Crosby said that. So we're going to have to wrap things up. I really want to thank you for watching this show. I hope you learned something tonight. And a lot of topics I talk about, sometimes they get down and dirty about them. And some of the topics I talked about tonight, some of them are very general, some of them are detailed. If you have any questions, give me a call. We can discuss your options. It's always a good thing to do to start speaking to an attorney before you make decisions, before things get out of control. Thanks for watching, and you have a good day.